want to welcome you to our show here today. It's really great. I have two great guests here. I have incredible Vistage chair Cheryl Marks Young. It's in the New Jersey area. Welcome, Cheryl.
Thank you.
Yeah, and I have Harry Barth, who is the founder and senior managing partner of the asset protection, estate planning, and business planning firm Barth Calderon. You can actually see our office here on my screen in Orange County, California, near Disneyland. I think, Harry, you can see the Matterhorn from your office there.
Yeah, we can.
Yeah, and we do a lot of these talks, and Cheryl has aligned with Harry to bring this education out to her network, and a very hot topic, which we're going to get into here in a minute, the Corporate Transparency Act. I want to start, Cheryl, with you and tell us about what you're doing with Vistage.
Sure. So I actually have three groups. As you all know, I was a member for almost 12 years, became a chair almost 6 years ago now, and have three groups that actually cross New York and New Jersey. And we're helping really wonderful, hungry, humble human CEOs and business owners grow their businesses and touch on these tough subjects on what gets in the way of growth and how to overcome those barriers and obstacles and help each other grow.
And Cheryl, you have open spots there? Who are you looking for to add to your groups there?
So hungry, humble human would be the definition of the business owner that I would be looking for. Also the name of the podcast. And looking for anybody really, and I know nobody wants to hear looking for anybody, but looking for business owners who are ready to grow and learn and help each other. And so we have openings for, I love manufacturing companies. I grew up in manufacturing, so that's always near and dear to my heart in any industry of manufacturing. We have some room for specialized attorneys in mergers and acquisitions and some IT folks. And honestly, anybody who steps forward, if it's not a fit for our group, I can definitely help someone that needs to grow their business and find them a Vistage group that works for them.
Wonderful. And I'll tell everybody that's watching this video, wherever you're watching it, that the contact information for Harry and Cheryl is going to be around this video. Maybe it's up here or down here if you're on YouTube or live or LinkedIn, wherever. But please network with them. And Harry, let's get into it. What do we need to know about the Corporate Transparency Act?
Oh boy. So we have a lot to talk about today, but I think that when we finish today, everyone will have a really good working knowledge of this particular act. And it's more than what you think. And so hopefully everyone will know what they have to do to comply. So first, definitionally. So one definition you'll hear me use a lot is the word FinCEN. And FinCEN is an acronym or a short version of the Financial Crimes Enforcement Network. And the Financial Crimes Enforcement Network is a subdivision of the United States Department of Treasury. And FinCEN Network is the governmental agency that's responsible for enforcing and implementing the Corporate Transparency Act. The Corporate Transparency Act was passed in 2021 in bipartisan legislation. And it was designed, its sole purpose is to build a registry, non-public registry of who are the human beings behind entities, small entities. So who are the human beings that are the limited partners? Who are the human beings who are the shareholders? Who are the human beings who are the members of LLCs? For your New York constituency at the end of this year, there is also a parallel New York LLC Transparency Act, which is actually more egregious than the Corporate Transparency Act. And we'll kind of put a few words in on that, but it's a little tangential to Corporate Transparency Act. Purpose of the act is to ferret out or try to find money launderers, people that are financing terrorism and tax evaders. And so that's the background of it. It's allegedly a noble purpose. The one thing we need to know about it is the government serious about this? So let's talk about the seriousness of it. Well, here's the deal. For each violation of the Corporate Transparency Act, so there are implementation dates, and we'll go talk about for new entities and for older entities, unless they're exempt. If we are not in compliance by the date we're supposed to be in compliance, it's a $591 a day fine with no maximum, all right, for each violation. So you can do the math. That could be quite significant, and that's going to be enforced by the Internal Revenue Service. Yuck, yuck, yuck. In addition to that, if you willfully do not comply with the act, it's a $10,000 criminal fine and up to 2 years in jail as a felony. So they are serious. The act, although passed in 2021, went into effect in full force January 1st, 2024. So we're about 115 days or so into the act. And so there's a lot to learn about it. Surprisingly enough, not too many people know as much as they should know. That's a fault of the government. The government's going to bring out such an important and highly penalized if we don't follow it act without doing all the necessary work to inform the constituency that's going to be impacted by this about the things they have to do is absolutely terrible. But it is what it is. So there are a couple of we'll call it attacks on the Corporate Transparency Act. Let me get those out of the way, and then we're going to get into a lot of specifics. Well, one was the National Small Business Association versus Yellen, which was a case that was heard in the First Northern District Federal Court in Alabama. And in that case, the judge ruled that on a summary judgment that the Corporate Transparency Act was unconstitutional. And the reason that the judge ruled that way is that the argument was that Congress did not have the power to pass the Corporate Transparency Act. And we'll talk more about that. But people need to understand the only people that deferred from filing are members of the National Small Business Association in Alabama. That's it. Everybody else is to file. And we also need to know that the government has already appealed that decision. The government feels, of course, that it's a rogue decision, and that the 11th Circuit Court of Appeals will overrule that judge. And we don't expect, and neither do I, expect any other appellate court or Supreme Court to overrule this. I mean, not overrule it. And the reason for that is that a version of this is already in effect in all the modern Western European economies and the modern Eastern economies, because the goal, I mean, you can't buy a piece of real estate without a notary and not saying who you are. So the purpose of the act seems good. This is just a constitutional question of congressional power, and that we have that. And there's another one, I think it was Boyd versus Yellen, and they're just talking about whether or not the federal government can impair the state's ability to regulate its entities that are issued by the state. We'll see where that one goes. But in the meantime, it's in full force and ready to go and subject to enforcement. So unless we're exempt, and I'll go through the exemptions in total, every single limited partnership, corporation, and LLC in America must file under the Corporate Transparency Act. There is an estimated 33 million entities that are going to be required to file before the end of this year. These are entities that are in existence before January 1st, 2024. Before January 1st, 2024, they have to file by December 31st, 2024, or the $591 a day fine begins. That 33 million turns into close to 200 million individual assignments. You'll learn about that as I go through with you today. So that's for pre-existing entities. For new entities that are formed after January 1st, 2024, 90 days, Cheryl, from the time that the Secretary of State's office in New York or New Jersey says, your LLC is good to go. On that 90th day, that entity must be in compliance with the Corporate Transparency Act. So it's 90 days for a new entity to the end of the year for a pre-existing entity that exists before January 1st, 2024. So this is really targeted to small business. And you'll understand that when I go through the exemptions. And why small business? Because that's where all the nefarious activities take place. It's in Molly and Mabel's hair salon, which may be a New Jersey S corporation in the back room where the cartel is functioning. It's not at AT&T. All right. So let's go through the exemptions and how that affects your constituency. So the exemptions from the act, who does not have to file? Let's run through it. So the first obvious exemption, not having to file, public companies. So if you're a member of if your stock is traded on New York Stock Exchange, American Stock Exchange, NASDAQ, SEC exchanges, they know all about who runs a company. They know your background. They know the background report. They know the credit reports. They got your fingerprints. They know they got your eye color, whatever, all the stuff that they need to have. They know who you are. Because the goal of this act is to find out who are the humans behind Blue Ocean LLC. Who are the people? Blue Ocean LLC doesn't cut it. It could be a cascade of shell companies, i.e. Pandora Papers, Panama Papers, things of that nature. So that's the goal. So big companies, no. SEC registered investment advisors, all right? And venture capital fund advisors are exempt. Same reason. They're registered with the SEC. They've been backgrounded. They've been checked. We know who the people are. So they don't have to file. Highly regulated financial institutions like banks, credit unions, registered broker-dealers, that are also highly regulated by states, federal government, SEC, Treasury Department. We know who they are as well. They are also exempt. Trust companies are exempt. Trusts are not born at a Secretary of State's office, but if a trust holds a company that's required to report, the trust becomes a reporting entity. And I'll teach you about that in a few minutes. So trust companies themselves know, trusts themselves know, but perhaps very significantly and almost universally, yes.
Harry, is that the living trust you're talking about? Revocable
Living
living trust?
trust, irrevocable trust, dynasty trust, asset protection trust, you name it, if it's a trust and it holds a ownership interest above the threshold in a reporting company, then every aspect of the trust needs to be reported. And that gets a little complicated. So let's continue on with our list. Insurance companies and insurance producers regulated by the state. They don't have to do it. Nonprofits, Red Cross, United Way, whatever it may be, Joe's Cat Rescue, don't need to report. Political organizations don't need to report. And governmental agencies don't need to report. And if the company itself is an exempt company, a wholly owned subsidiary of that company also does not need to report. But that has nothing to do with brother, sister entities that I'll talk about in a moment. But the one that impacts, Cheryl, your constituency the most is what they call the large company exemption. This is an and, not an or. So here we go. If the company has 20 full-time employees as defined by state law, not part-timers, not contract employees, full-time employees, and they have their office in the United States of America, and they have over $5 million of gross sales, they are exempt from having to file under the Corporate Transparency Act. So, but if they have $12 million worth of gross sales, but only 15 employees, they have to file. So it's an and structure. And what happens that encompasses a lot of Vistage members. But let me give you an example of what we see. So let's use me for example, Barth Calderon. We have way north of 20 employees. We have our office in the United States of America, and we have way north of $5 million worth of gross sales. So Barth Calderon, the law firm, does not need to file under the Corporate Transparency Act. But Harry has 12 entities that hold real property, investments, intellectual property, and other sorts of and other businesses. So Harry has 12 entities, and most Vistage members will have the mothership, but they will have the satellites, and all of those satellites are reporting entities. And then what happens if, hey, they had 22 employees, but then we have a bit of a recession, so they laid off some employees. Now they have 18. All of a sudden, they become a filing entity. And how long do they have to file, and how does it drop? It's really, really complicated. Okay. So there we go. Those are the exemptions. So now let's turn around, and what we're going to do is, Cheryl, you and I, we're going to form an entity. We'll do it in New Jersey. Why not? We could do it in New York, but we'll do it in New Jersey today on the other side of the bridge. And we're going to form a new entity in April 15th. We'll do it on tax day, and we'll call it Sherry Harry Co. LLC. And of course, you and I were going to sell widgets, because what else would we sell? And we have two DBAs. One DBA, which is widgets are us, and the other DBA is widgets are them. Okay. We don't fall under any of the exemptions whatsoever, so we are a filing entity. So 90 days from April 15th, when the Secretary of State of New Jersey issued our articles of organization of our LLC, we must comply with the Corporate Transparency Act. Now, the first thing we need to understand about the Corporate Transparency Act is who is the actual filer, or the responsible for filing. Under the Act, which must be done electronically, into the FinCEN network website, www.fincen.gov, and Paul will put that up in the chat. The entity, our entity, Cheryl Harry Co. LLC, is responsible for all of its reporting within the 90 days. So what do we got to do? So we got to go on FinCEN, and we have to report our company. So what do we have to do? Well, we got to give them our name. So there's our name, Cheryl Harry Co. LLC. We must give them every DBA that we have. If we had a new DBA, we have to add that too. So widgets are us, widgets are them. We must give them the physical address of our company. So not the lawyer's office where it was formed, not the CPA's office, not a UPS suite, not a post office box, where the company actually lives. If it lives at your house, Cheryl, your house has to go to FinCEN. Then in addition, we have to give a unique identifying number. And that number, in most cases, when we filed our company, we put our company together, was our EIN number that we got from the IRS, 33 dash blah, 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 blah. We put that in. If it's a single member disregarded entity, like an LLC could be, then we would have to report our social security number to FinCEN. So now we have our entity, and we have now filed the required documents at the FinCEN website. And so we begin. Now, the entity is responsible for reporting all of its beneficial owners of interest. It's called a BOI. And that basically says anyone that owns 25% or more of our company must report, unless they're a minor. If they're a minor, their parents must report on behalf of the minor. So you own 50%, I own 50%. We are beneficial owners of our company. We must report. So the company is responsible, Cheryl Harry Co., to make sure that Cheryl and Harry are now reporting their information. What must we report? So we have to report a name, Cheryl Marks Young. We need to put your physical home address down. Yuck, yuck, yuck. All right. And you need to upload a color copy PDF of either an unexpired driver's license or an unexpired passport. Those must go to FinCEN. Now, you got to do that, and I got to do that. And there we go. And now I'll talk in a few minutes about getting a FinCEN number, but now we have reported the two owners. But now you and I say, We're good Vistage members. We've been, working real hard. We hired, for our LLC, we hired a manager. We could have been the managers, but we hired a manager. And the manager to manage our LLC for us, we hired a Polco, which is a New York S corporation. And Polco is going to run Widgets R Us for the benefit of the owners, Harry and Cheryl. One of the things that is not clear for people to understand under the Corporate Transparency Act is we must also report everyone who has substantial control of the company. It's not only ownership, it's also control. Now, the manager of that LLC, the general partner of a limited partnership, all right, or the president of the company. So now Polco has to report because it manages us and has substantial control over a reporting company. So Polco, who has to report in Polco on our behalf? Well, the CEO, the COO, the president, the CFO, anyone who has substantial control, authority, or decision-making authority over Cheryl and Harry Co. also must report their name, their home address, their driver's license and or passport. And if Polco has a board of directors that can remove and replace a C-suite member, every member of the board of directors must report as well.
So, question,
Yeah.
under Harry and Cheryl Co. and under Paul Co.
Yeah.
Wow.
Well, but Polco because of its controlling interest. So form a limited partnership, Cheryl, you and I, 99% we're the LP, and we have a GP, 1%. The GP has all the control, right? GP has to report. We can have 5 members of our LLC, 2020, 2020. No one has 25%, so the members don't have to report, but who controls the entity has to report. We can have 99, we can have 33, 33 ownership of our LLC, and then 1% holding the voting interest, they have to report. But now you see, Cheryl, we've done some estate planning, and with good estate planning, we know we don't want to have your 50% ownership interest held in your name and wind up in probate, surrogates court, or and so therefore we just wanted to put it into. We weren't fancy at this point. We didn't set up a dynasty trust for the kids. We didn't do an asset protection trust. We didn't do a gifting trust. Just a living revocable trust that all of us pretty much have or should have for the benefit of our estate planning. So we took Cheryl's 50% interest in Harry Shelco and put it in the trust. So although the trust itself doesn't get born to the Secretary of State, it owns 50% in a reporting company. Ugh. So now what? So that means that the trust becomes a reporting entity. So now what do we have to report? So for your 50% interest, we need to report who formed the trust. Whoever's the creators of the trust, because creators of the trust have powers. You could remove assets, replace assets, revoke the trust, whatever it be. So you have power, so they have to report. The trustees have to report. The beneficiaries have to report. The trust protectors have to report. And in a more advanced trust, you have directed trustees, investment trustees, distribution trustees. They all have to report. And if someone holds something what we call like a power of appointment, which is the ability to direct assets inside a trust and where they go, whoever holds those powers or a voting trust needs to report. Oh boy, oh boy, oh boy. So, and this is just our little entity. So let's just take this, and then I'll talk about FinCEN number. Let's just I was talking to a Vistage chair a couple of weeks ago in Texas, and we were talking about the Corporate Transparency Act. So he says, Harry, most of my members, he said, they're in, of course, what are they in? They're in the oil and gas business. They're either raising cattle or in the oil and gas business. That's all the heck it seems that anyone does in Texas. So he turns around and says, well, let me ask you a question. He says, when we drill an oil well here, it's a risky business. I said, yes. He says, it could blow out, it can catch on fire, it could pollute the ground, people can get hurt. It's a very, very difficult business. So we always form each well that we drill is a separate LLC, appropriate for asset protection purposes. I said, correct. I know we do them. So he said, yes. He says, so that the oil well becomes a reporting company. Then we go further because what happens is that the people that invest in the oil well, so let's say the three of us, Paul, Harry, and Cheryl, we want to invest in that oil. We're going to drill for oil. But it's too much risk. So how do we invest in that LLC? We each form an LLC. So Cheryl's LLC is an investor, Harry's LLC is an investor, Paul's LLC is an investor. So all of those LLCs are also reporting entities. But this is not our only oil well. So they're not one-trick ponies. We have several oil wells that we invest in, maybe 10 or 12. So we have a holding company that holds all our oil well investment LLCs. The holding company becomes reporting. And the holding company is in my dynasty trust for the benefit of the generations to come ahead. So every aspect of the dynasty trust has to be reported and all the control factors. On a scenario like that, on one oil well, you can have 50 reporting transactions.
Right.
Ugh. Gets better. So now you would think that they'd be satisfied. For all entities formed after January 1st, 2024, there's another category. It's called the company applicant. What the heck is the company applicant? So the company applicant is the law firm that filed the paperwork with New Jersey. So if you came to me and said, Harry, let's make Harry Cheryl Co., and I decided it should be an LLC, and my paralegal, Cheyenne, filed the paperwork with the Secretary of State in New Jersey, she has to report as the filer. So Cheyenne Petty and her information has to report. And if I'm the attorney that is supervising that paralegal, as the supervising attorney, I have to report as well. So I have who formed it, who owns it, who controls it. The goal is who are the human beings behind the veil. Now, here's a little trick that it would bring out for all the members and the people that are listening to this. One of the things they could do, now, in most cases, just before we get there, who does all this? Of course, there's a lot of burden and time trying to navigate a Byzantine government website to try to file this stuff. So the AICPA, you may have heard of them, the American Institute of Certified Public Accountants, have come out with a, call it an edict, that they recommend that none of their members deal with the Corporate Transparency Act because they consider it to be the unauthorized practice of law. So you got a couple things. Not doing this right, believe it or not, it could be a felony. So I think you'd want to have attorney-client privilege. And two, navigating what is substantial control? It's a legal definition. What is ownership? Legal definition, because they're held by different entities, and people die and it's in probate administration, or it's in this, or it's in trust administration. And when you're looking at the estate documents that all of us have and trusts that hold these entities, the myriad of complexity inside a trust needs to be evaluated as to who's reporting, who's not, who has control and who doesn't. So not as an advertisement for lawyers, but I would think that it's good to have a professional that knows this field very well to help do so. And I'll talk about that in a little while. But what is the trick? All right. So the trick is that this we can't do for you. So Cheryl, and you should do this. Go to that FinCEN website and establish an account. All right. And how do you establish an account? Well, you give them the information. You give them your name, your address, you upload your driver's license from New Jersey, and they say, thank you, Cheryl. After knowing where you went to elementary school, the color of your first dog, and all the other stuff that goes along with it, and two-factor authentication, that's where we can't do it for you. They will issue you a number. It's kind of like a social security number, it's a FinCEN number. So every time you are involved under the Corporate Transparency Act, you'd put down Cheryl Marks Young, number, blah, 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 blah. And you don't have to upload your driver's license again or give that information or your home address to everybody that you're involved with a transaction with. So it's really important. It took me about a half hour to get my number because I'm a supervising attorney. We've done like 300 transactions since January. And for 300 times, I would have to put my home address and all my driver's license and passport. I'm not interested in doing that, so I gave them the number. So you're now looking at what's required under the the Corporate Transparency Act. So in that new entity that we just formed, we got 90 days to kind of fill all that out. So what we're doing now with our clients is when we form a new entity, a new limited partnership, a new LLC, new corporation, we just incorporate that in our filing. So we will bring it through to figure out who, because we're doing it, we know who the owners are, we know if we're going to put it in a trust. So we can figure out the map of who the BOIs are. And then we have a service that for $250 will sit, on FinCEN website and fill these 50 things in, or you're more than welcome to spend 8 hours to try to do it on your own. So what else had to happen is in every new operating agreement, shareholders agreement, limited partnership agreement, new section, Corporate Transparency Act. So you and I got to sign that agreement. And in it says that there is a Corporate Transparency Act, that we will provide our information. You can't be a member of Cheryl and Harry Co. unless you sign this agreement. And when you sign this, you are agreeing to provide your information to FinCEN, because otherwise we, the company, are held responsible. So if Paul says, hey, I want to be a member and we're willing to give him a third of our company, but he's not willing to comply with FinCEN, he's not going to be a member of our company. If he's already a member of our company and is not willing to provide his information, two things happen. One, he will be fined. He will eventually be jailed, right, for not doing it. We will be fined. We will have to get rid of him, and maybe we try to buy him out at half book value to get rid. It's a good time to weed out bad players. And so we have that. Now, good side, bad side. So good side. The Corporate Transparency Act is a one and done filing. It's not an annual filing. So once Cheryl, you and I have filed our company and reported all the BOIs, absent changes, we're done. So, however, now if you decide to go from New Jersey and move to Yonkers or someplace like that, and now you've changed your address from Jersey to Yonkers, and now you have a New York driver's license, your FinCEN information is changed. You now, under current law, only have 30 days to file with FinCEN your new address and your new driver's license from the date it was issued to you, or $591 a day fine. There are no exceptions. There are nothing. In other words, it has to be complete, or FinCEN has been instructed by Congress not to accept it. Opportunity gives every one of our members in our constituency the opportunity to revisit those shareholders agreements, those operating agreements, those partnership agreements that usually are woefully out of date. The cap tables have changed. People are dead. They've sold out interests. All these transactions that take place. You look at the original shareholders agreement. It was never changed. They never issued shares. So it's a time to get corporate and business housekeeping up to speed. Maybe it's triggered by this ridiculous act, but it is what it is. Now, the other issue that we face with this is that there's a tremendous amount of sensitive information that's going to be running around the country. And even on the FinCEN website, they already have warnings that, you got to be careful. That a bunch of people trying to scam you out of that information. Cybercrime is a big deal. So that says for those of us that are helping people with the Corporate Transparency Act, it tells us we have to have secure portals. Things have to be encrypted. So we, as a law firm, we've always had it, but we have to have even greater, because the volume is greater of stuff. And then we have the issue of what happens for the 33 million companies that are pre-existing prior to January. We have till December 31st. But man, it's not easy, because we got to figure out, one thing we don't have to figure out, for every entity that was in existence that's not exempt prior to January 1st, 2024, the company applicant, who the lawyer and the paralegal did it, we don't have to give that information, thank God. But we do everything else we do. So we now have to look at that entity that members have, who controls it, who owns it, right? How is it held? If it's held in your trust, those things could be so complicated, and things could have changed over the years, and people have died, and things went through probate, and now they're with beneficiaries, and then they got married, they got divorced. They're not talking. One spouse doesn't want the other spouse to even know where the other spouse lives, but yet they're reporting. This gets to be some really easy, but some of these maps that are required to figure out ownership and control will take significant amounts of time and cost. So just give you an example of what we've done. We've made a decision in the law firm to provide our clients, and some people that are not our clients will evaluate an entity for like $595, which is not even an hour of attorney's time, and we'll have people who will file it with FinCEN for $250. To me, that's a bargain. They should find someone similar to us or us to do that. Don't attempt it on your own. It's not worth it. And so those are that's now you have a relatively good idea of what it could be simple or it could be extremely complicated. There's one other piece of legislation that's floating through Congress right now, and they're primarily extensions. So the extension is in this legislation, the time for changes right now, we only have 30 days to report a change. We want to extend that to 90 days. And the other is to change the December 31st, 2024 deadline to December 31st, 2025 deadline, because I don't know in hell how they're going to, we're going to register 33 million small businesses by the end of December. I don't even think it's possible. Yet the enforcement provisions are in full effect. So there you have inherently everything that you need to know about the Corporate Transparency Act. Just let me put out an editorial, based on my close to 50 years experience, and that is, I think it's here to stay. Maybe some aspects of it that might be unconstitutional, but inherently, know your client, Patriot Act, notarizations all require, where do you live? Just give you a driver's license, thumbprints, thing. You got it. It's already here. So I don't think that it's going to go away, but I don't think it's going to accomplish the goals. It's going to place a burden, both in time and cost, on America's small business. Do I think that after all this burden, after all these fines, after all the enforcement, it's going to stop terrorist financing, money laundering, and tax evaders, the criminals? I don't think so. They'll find a way. They'll create people with AI. They're very sophisticated. So the burden's going to be here. The overreaching is going to be here. And this alleged non-public database will be there for law enforcement. Do I think it will have much of an impact on nefarious activities? No. But that was just my humble opinion of what I think of the Corporate Transparency Act. But it is what it is. So with that, why don't we fire away questions? I know, Cheryl, you may have some. Paul, you may have some. It's time to go for it.
I have a bunch. You want to go first, or?
Yeah, no, you go, Cheryl.
Go ahead,
jump
go,
in.
Cheryl.
So I have to say, you did actually answer many of my questions that I had already written, because I'd done a little bit of research. So I'm grateful that you talked about the cases that were currently in place. I am concerned about the security, and it makes me want to caution people to, if you have a system, and I don't get any money for saying this, but if you have a system like a LifeLock or some other protection, make sure it's turned on and up to date, which makes me want to go back and look at my own. But you said nonprofits are exempt, and
Yes.
yet I sit on the board of several non-for-profits, and we are, not that I want to add myself to the mix, and I have to anyway, but those people have the ability to direct that not-for-profit and to remove the current executive directors of those not-for-profits. So do you think
Non-for-profits are exempt from the act.
and you foresee
Now,
that
why?
staying?
No, I don't, because I don't see why a small nonprofit, Joe's Cat Rescue, that has some people on the board and they're collecting money, except I think that when people make a contribution to a nonprofit, it gets reported. to the IRS as a donation. I don't know. To
And the
me,
officers are reported on the 990 and
they
their home
are,
addresses. Are
yes,
they
they are.
considering that that's already handled?
I guess so. I have no, when trying to figure out the wisdom of what Congress does is a fool's errand. But nonprofits at this point, now that doesn't necessarily mean that by the time we wake up on December 31st, there's an amendment to the act and nonprofits under a certain size will be included under the Corporate Transparency Act. It's kind of ludicrous that they're not, but it's
Mm.
not right now.
It makes no sense. And the other
No,
question is, some of our members across Vistage, some of the smaller members are single member LLCs that may or may not, and I'll go with the may be, exempt for tax purposes because they're able to somehow file it themselves.
no, no,
That
no, no,
should
no, no,
that
no, no,
should
no,
still
no,
report,
no, no,
correct?
no. So let's correct that. So they're not exempt for tax purposes. That's called a tax disregarded entity.
Thank you. I used
Okay.
the wrong words. I
Yeah.
appreciate
So so they are fully taxed. It's just a pass through entities. In other words, for tax purposes, they don't exist, those entities. So they report all their information on the Schedule C on their
that. Right.
tax returns. But it is an entity and it's not exempt.
It's
On
not
that
exempt.
one, they report their names.
Right.
They would report as BOIs, the owners, because they own 100%, their home addresses. Okay, their EIN number would be their social security number. And for the owner, they would also have to report, all the driver's licenses and everything else. And then remember, they're also you could form a single member LLC, but you could have it managed by Harry. So Harry would have to report, and then you're going to take that single member LLC, which is disregarded for tax purposes, you put it inside your trust. Now your trust owns 100% of the disregarded entity, so it becomes a reporting entity. So it's not an exempt entity; it's fully reporting.
And that's what I want to make sure is that we don't overlook something and then wind up
Yeah,
getting a
and
letter and thinking
right,
what just happened.
and that's literally what they're after because it's in those kinds of entities because they have a name. Remember, it's Blue Ocean LLC. It might be a single member tax disregarded entity owned by Cheryl Marks Young, right? But they don't know who necessarily owns it. You filed it in Wyoming. This doesn't say who the managers and the members are, or Delaware doesn't say who the managers and members are. Now, New York goes further. New York's Corporate Transparency Act, which is the New York LLC Transparency Act, interestingly enough, New York does not apply to corporations, does not apply to limited partnerships, only applies to LLCs. And in New York, if you don't comply and give all the information, which is very similar, you'll be deauthorized from doing business in New York.
Mm.
Done. They want to know who are the beneficial owners and humans behind every LLC. And it's just LLCs. So you form a limited partnership with a corporate general partner, and there's no reporting in New York. You have to report under the CTA, but not under the New York Act. And then the New York Act is a piling on top of the CTA. You got to file both, you know? And this may be a trend across the country where now the states are saying, okay, we want a Transparency Act too. So next thing you know, if you form your entity in New Jersey, you're authorized to do business in New York, all right? And so you got a CTA filing, you have a New York transparency filing, and eventually you might even have a New Jersey. It is ridiculous.
Cheryl, I was going to
Out of
mention too
control.
that what's come up before in these talks is some Vistage members with bigger companies that are exempt say, "Oh, I'm exempt with my big company," but what Harry does constantly is carves out IP vehicles from big companies into brother sister relationships.
Equipment, real estate, for asset protection. And one of the dangers that I see of this act, well, what's one and done in compliance and only changes. And, people are going to have to comply. The biggest danger is for people to take a position. No, I'm not going to hold my real estate in an appropriately designed LLC. I'm just going to put it in my living revocable trust. Now they have unlimited landlord tenant liability to the full extent of their net worth. And if they have a liability to them, they lose their property. So proper asset protection planning, which is my business, and proper estate planning could have a chilling effect on that because people are concerned about providing further information to the government. And that is really detrimental. So you have the detrimental in not doing something that they should be doing. and you have the good side where it's a great time to take inventory of all your corporate and business founding and fundamental documents.
Right. So it's all the hidden doorways, which Paul, I think is what you were getting at,
Yes.
as we start to separate organizations into the different pieces because it's better from a tax standpoint or even a business operation. We now have more entities that we have to report under this Corporate Transparency Act than we thought. And
Once.
there's more
Once.
threads or more
Right.
tails.
More
that people
threads,
have.
but once. That's really important. It's not public, and it's once absent changes.
Right.
And but it's also very important to understand that there can't be any holes. In other words, if we needed 59 reporting transactions, and we had 57 of them, FinCEN has been instructed by Congress not to accept our filing. Can't take it. So now we literally are supposed to say these two not there, they're willfully not complying. They're supposed to rat them out, and then they can be charged with a felony for interfering with our ability to file CTA because FinCEN won't file it. And if we don't rat them out and take care of it, our company itself is a $591 a day fine. Not criminal, but it's the morat and of course it's so new that enforcement hasn't started yet because you don't have you're coming up on the 90 days now. March 30th was the 90 days for an entity formed on January 1st. And so enforcement hasn't started. When enforcement starts, the proverbial poop's going to hit the fan, and boy, oh boy, this is going to be, and the hope is that be enough, we'll call it angst amongst the populace, and maybe they'll back down a little bit, make it a little easier, maybe cut back on penalties, deal with what we can do with some exceptions, but they don't want exceptions. It's because it's in the exceptions where the criminals operate.
It's
So
almost like you need a forensic specialist to pull apart, because I could see the new companies forming now, understanding or figuring out all the pieces and all the players, but it's the companies have been around for a while that have bought and sold and moved things
correct.
around.
That's what we do for a living. You'd
Yeah.
have to find an organization similar to ours. Like I got 30 lawyers that work with me. And if you don't, we have the knowledge, that forensic knowledge to figure out that map and to get it filed for them. If they don't have that, attempt to do it on their own, I'm just afraid that it's just going to be a problem. And it's not an advertised, not self-serving, it's just, this is what was thrown upon us. I think it's horrible, actually. And it is what it is.
It is. Have you seen any, the things that I've seen in the last couple of months are people who are saying you need to advocate, call your congressperson, call your senator, and advocate to have this sort of shifted. What I'm hearing you say is it's kind of here to stay, because this is just really a formalization of what has already kind of been in
Yes,
place in pieces.
I think that what was said by the Alabama federal district court judge in the summary judgment is a great conclusion, other than what questions that you might have for our time together. And he said that, in making his rulings, that there are many pieces of absolutely ridiculous legislation that are constitutional. He said, and this is a highly noble piece of legislation, bipartisan legislation. Who doesn't want to be safer from terrorists? Who doesn't want to have money launderers come under the gun? We all do. The criminals. He said, that doesn't make it constitutional. And so do you have the government has been at this since 9/11. They've been at it, know your client, Patriot Act, notaries, know your client was a big deal, Sarbanes-Oxley. And then you had, I said it in passing, you had the scandal of the Pandora Papers, you had the scandal of the Panama Papers with notable people hiding behind layers and shells of these offshore LLCs and onshore LLCs in jurisdictions like Wyoming and Delaware, South Dakota, Nevada, that do not disclose who the members and managers are. And it makes it really difficult. And if you even watch FBI on Tuesday nights, you'll see them. It's the 5 shell companies in, and we don't know who's behind that shell company. We got to figure it out, because crimes are committed. So I think it's here to stay. I think there's going to be some modifications. But I think those modifications are mostly around appropriate and proper civil procedure and enforcement. And very difficult for Cheryl and Harry to be responsible for Paul. We should have the ability to figure out something to do about that. But anything that we do that allows anyone to be an owner and not be disclosed defeats the whole purpose of the act. So it's really challenging.
Yeah.
Okay.
Yeah. We good. Well, awesome. Great information, Harry, as usual, Cheryl, and great questions. And thanks for making this happen. And again, contact information in a way to get, if you have questions with Harry and the team one-on-one, we'll put that up there. If you want to get with Cheryl, we'll put it up there. Thank you both.
But one thing before you go,
Yeah.
so Cheryl, although not at live, but we are bringing out a series of the upcoming estate planning apocalypse. So with the New York estate tax, the changes coming in the federal estate taxes, it's going to impact every one of your members. Come in, we do an hour on that. It's just as informative, and I think even more critical than the CTA. So that's available to you, and it's free.
Thank you. Appreciate that.
All right. Okay. So Cheryl, thank you. Pleasure. Paul, thank you.
Mhm.
All of you have a great weekend.
Thank you.
Take care. Bye-bye.
All right.